Thanks for joining us today. This is part of a series of videos that the Texas Tech Law School is providing for veterans who have disabilities and various issues that relate to their access to public services. Today we're going to talk to you a little bit about access to housing issues, parking, ability to use a service dog, and various other issues. I do want to thank the men and women in uniform today and those who have previously served for the service to the United States. Today we have 3 of those veterans with us to talk to you about these issues. Michael Ludwig, who we call Ms., is a former Marine. Bailey McShane is a former Marine. And Chet Southworth has 20 years with the U.S. Navy. And they're here to help you with explanations about various particular disability laws that you may find important. One that frequently comes up is getting a placard, being able to park in an accessible, handicapped, accessible parking space. The Texas definition for that is a little bit different than what we're going to talk to you about later in the federal laws, and it focuses more on whether you have a mobility that substantially limits your ability to move around. It will also focus on what your vision is either before or after corrections in order to determine if you're eligible for a particular placard for parking. Ms., can you tell us about the registration process for the veterans' plates?
Of course. First of all, in order to register for a veteran's disabled license plate, you have to be a Texas resident, you have to be a veteran of the United States Armed Forces, and have a service-connected disability of at least 50%, or at least 40% due to the amputation of a lower extremity. You have to receive compensation from the federal government as a result of that disability, and the vehicle has to be titled in your name.
If a veteran wants to apply to get those specialized plates so that they can park in those spaces, what's the process? What forms do they have to complete?
The application is a form VTR-615 for disabled veteran license plates and parking placards. The cost for the first set of disabled plates is $3. Additional sets of license plates cost the same as a regular registration for the fee for the vehicle, and the license plates may be personalized for an additional cost of $40.
And if someone's not eligible for the plates, they can go through the traditional placard option. So, Chet, can you tell us about that?
Yes, I can. There's 2 different types of placards for parking. There's the blue placard, which means permanently disabled. They're good for 4 years. There's no charge for the first one. There's red placards. Red placards are for temporary disabilities. The temporary disability is for 6-month maximum or until the end of the disability, whichever one comes first. There is a $5 charge for the placards and a maximum of 2 red placards that can be issued at a time.
Okay. If a veteran has the blue placard, do they have to renew it, or is it good forever? What's the process with that?
Well, the blue placard it's good for 4 years. To get one, a new one or a renewal, they bring down a form. It's VTR 214, easy for veterans to remember. DD 214 is our retirement paperwork. It's VTR 214. They bring it down to the tax assessor's office, complete with their signature and a letter explaining the disability, the percentage disability, and they get their placard.
And this is available even if they don't meet the requirements to get a veteran's license plate with a service-connected disability.
Correct.
So somebody who's disabled after they've served, but the disability is not service-connected, can still get one of these placards.
They still get one. They just need to bring in a doctor's certification.
Okay. Are there limitations on where they can park when they have that, Bailey?
According to the Attorney General's opinion, H-1291, veterans are allowed to park at any parking meter, and they're exempt from the tolls. However, there are restrictions on time limits at some meters, and for those, veterans should not abuse this privilege. However, they will be exempted if they also display a blue placard in their windshield.
So if it's a 2-hour parking space, you shouldn't be parking there all day, even though you're exempt from paying the amounts?
Exactly. It's not a, I guess, privilege to be abused.
If you park in the space that's marked as an accessible parking space, and you're not supposed to be there, either you don't have a disability or you have some other problem, what can happen to the person who inappropriately uses those spaces? Is there any penalty for that?
Those who are not authorized to park in those spaces can face misdemeanor charges, and there also could be assessed fines anywhere from $550 to $750, and for repeat offenders, that fine can raise to $1,250.
What about the owners that have the placards? Are they exempt from these penalties?
Owners displaying plates, either of disabled veterans or the blue placards, are able to park in these spots, and the red placards, while they are still active and no longer, not expired, excuse
So
me.
can they park anywhere, or are there some limitations to where they can park once they have that red placard or that blue placard?
There are a few limitations. If you have a blue placard, you can park anywhere where you are able to. However, this exemption does not apply to any branch of the government or a governmental unit that operates a parking structure or parking area around a municipal airport.
So those are specialized.
Yes,
Areas for
airports
that.
are specialized areas.
Okay. Let's transfer a little bit and talk about housing, whether it's buying a house or whether it's apartments. There's some federal laws that define what that is, and we'll cover that a little bit more in detail. But I'd really like to start talking about what rights does a person with a disability or a veteran with a disability have in the housing context. Ms., can you talk about some of the federal laws and what's involved?
Yeah. First off, federal law prohibits discrimination against any people or persons with disabilities. It's unlawful for a housing provider to refuse to rent or sell to a person simply because of their disability. Also, a housing provider may not impose different application or qualification criteria, rental fees or sale prices, and any rental sales or termed conditions of those required or provided to people that aren't disabled. So you can't discriminate against someone because they're disabled or change anything based on their disability.
What if there's a veteran with a non-visual disability like a brain injury or PTSD and the landlord becomes aware of that? Is that included in that?
Yes. For instance, if a veteran has a mental disability that wants to rent out a place or buy a housing provider can't refuse to rent or sell that place to the veteran with their mental disability based on their uncomfortableness or whatever problem they might have with that disability. For instance, if a veteran with PTSD or something wanted to rent an apartment, the apartment or housing provider couldn't not rent to them or impose conditions based on the fact that they have PTSD if they're scared or worried or troublesome about that disability itself. That type of act would violate the Fair Housing Act because it denies a person housing solely on the basis of their disability.
And the definition for this is a little bit different than what we talked about in the Texas Transportation Code. In this area, it can be a mental or physical disability that affects one or more major life activities. Is that right?
Yes.
Okay, so that's different than what we heard in the Transportation Code part. What about in renting and selling? Is there an application process that can be different if the person has a disability? Can they do some process different if you notify them that you have a disability?
No, they can't change any requirements or any application process simply because the person's disabled.
What could they do? If somebody's asked for some accommodation or they've asked for some process, what could they refuse them?
I'm not sure what your question is. What you mean, refuse them based on their disability? That would violate the Fair Housing Act if it's based solely on their disability. I think Chet's going to talk more about the Fair Housing Act and why it's so important.
Yeah, Chet, let's talk about the definition of that. Can you kind of explain to me what the Fair Housing Act includes and what it covers and protects?
Fair Housing Act, well, it defines a person with a disability as someone with a physical or a mental impairment, that it substantially limits one or more of their major life activities. This can include things like speech impairments, visual impairments, cerebral palsy, epilepsy, heart disease, diabetes, things of this sort. It's all sorts of different things. Even things such as HIV, mental illness, drug addiction, not to illegal drugs, or even alcoholism. Major life activities includes things like speaking, seeing, hearing, breathing, performing manual tasks, basically caring for yourself. Fair Housing Act is really important, and it applies to all people, including veterans, to make sure that they get the housing of their choice.
What does it protect? What rights are protected by the Fair Housing Act?
It protects them from housing people refusing to provide them with either rental units, purchasing properties, anything like that, or even applying for a rental or a purchase of a property. Basically, it wants them to allow people with disabilities to get reasonable accommodations.
Let's talk about that a little bit more. Bailey, let's talk about reasonable accommodations. What is a reasonable accommodation?
A reasonable accommodation is any change in policy or practice that a service provider may make to allow equal use and opportunity for, a dwelling or a common area for someone with disabilities.
At what point does a landlord or a potential landlord have to provide reasonable accommodations? What part in the process?
A reasonable accommodation needs to be provided unless it will fundamentally alter the service that's being provided or provide too much of a financial or administrative burden on that provider, because at that point it needs to be looked at a case-by-case basis as to how it will help the disabled person and affect the provider of that service.
So, for instance, if somebody has a heart condition, they live on the second floor and there's no elevator, if they want a first floor apartment, is that a reasonable accommodation request?
It would be a case-by-case basis, and what the change in price or accommodating that person in some way. Governmental agencies and others so situated, apartment or real estate agents also have to be worried about that, but it's a case-by-case basis at that point, and a reasonable accommodation is not a complete blank check to allow individuals with disabilities to live wherever they please.
Well, it has to be reasonable, but if the landlord just keeps saying, we are not going to provide that accommodation, can you tell us when they can legally deny the accommodation?
Yes, they can legally deny the accommodation when there is no disability, or if the accommodation being requested is not related to that disability. Also, if it would change the type of service that's being provided or create too much of an undue financial or administrative burden on those people providing the service.
And how would you determine that? I mean, if the landlord's going to, their response is easy, their defense is, hey, it's an undue burden, it's going to cost too much, how do you figure that out?
That's going to be a case-by-case basis. They're going to look at factors including the cost of the requested accommodation and the benefit it would actually create for that person with the disability.
And I would like to add, when you're figuring that cost, then you also look at how much money they've got. So a small individual apartment might be easier to show it's an unreasonable cost versus a multi-chain apartment complex. It may depend on where the veteran is going for the housing to do that. Aside from the reasonable accommodation, is there anything else that they should know about their housing rights, Ms.?
I'd like to add that under the law, housing providers are required to allow persons with disabilities to make reasonable modifications. A reasonable modification is a structural modification that is made to allow persons with disabilities the full enjoyment of housing and related facilities. For example, a reasonable modification can be installing a ramp for handicap access or installing a grab bar in the bathroom. It's important to keep in mind that typically reasonable modifications are made at the resident's expense and not the provider's.
So someone can't go in and say, I need a ramp, and you, the landlord, has to build the ramp for me?
No.
In front of my door? They can't say, I need a wider door for my wheelchair, and you, the landlord, has to pay for that?
No.
But they have to let you do it if you pay for those.
That's correct.
Okay. Let's go to the kind of a one that's affecting a lot of people right now and talk about service animals. Especially with veterans, that's a big issue these days. And there's not always a clear understanding of what that is because a service animal, the definition changed in 2008. So it doesn't account for every animal that may be providing a service, but it can only be a dog, and that dog has to be trained to do an individual task to help with the disability and individually trained to do that. So that's a little bit different from the emotional support animals, which we're going to talk about in some of these areas. Somewhat confusing with a psychiatric service animal because there can be a psychiatric service animal who's not an emotional support animal. They're actually trained to do a task. They alert on an oncoming anxiety or panic attack. So we're going to need to distinguish that as we talk today about the difference between the service animals and the emotional support animals. Chet, can you tell us some of the misconceptions that are out there today about these particular ones?
A lot of people assume that service animals are required to complete some sort of training, or maybe to wear some sort of vest or other identification. And this is not needed under both state and federal law. They're not required to be professionally trained. They're not required to have any certification. They're not required to have any kind of a vest, collar, tag, or anything else to identify them as a service animal.
They do have to be tethered, though, to the handler usually, don't they?
They do usually have to be tethered to the handler, yes.
Unless that would affect, like, the movement of a wheelchair or something like that.
Yes.
So you can't have a service dog running wild. People are going to wonder if it's a service dog.
True.
Okay. How is that handled? It's if somebody's out in a public place and they've got their service animal with them, and by public place, I'm really talking more about a public accommodation. So restaurants, clubs, grocery stores, businesses, attorneys' offices, doctors' offices. When we talk about those businesses, what could an employee of my office ask somebody who wanted to bring their service animal in?
Well, an employee of your business, your office, would do the same thing as an employee in a restaurant or any other business would. They can only ask two questions. One, is the dog or service animal required because of a disability? Two, what work or task has the dog or service animal been trained to perform? They can't ask things like, let me see the certification. They can't ask things like, oh, show me the task it's supposed to perform. They also can't ask, what kind of disability do you have?
Not an invasive questioning process.
That is correct.
Which makes sense because service animals are supposed to make it easier for these veterans to go into places, not make them subject to cross-examination by employees of a restaurant. So it makes sense when you're on that side of it to see what it is. What if is it different if a veteran wants to take his service dog to work with him or her?
In a work environment, the other employees may be affected by it, but normally they will bring in certification to the employer. It won't specify the type of disability that the veteran has. It will simply be a letter informing the employer that the veteran needs a service animal or support animal at work.
So any information the employer gets about the disability is limited enough to show that the person really needs the service animal.
That is correct.
They're not going to get all your medical records from 20 years ago.
That is correct.
Okay. What if one of the fellow employees has a problem? You've got a fellow employee who says, a dog bit me when I was a kid, or I'm allergic to dogs. Can an employer then say, well, this other employee has an allergy, so you can't come to work with your dog?
The employer can make reasonable accommodations. He can have the employee that is concerned sit as far away as possible or in a different room. He can separate them, but they cannot restrict the service animal from the premises.
And I would like to just point out that a lot of that's available from an online. If you're an employer, you can go on the Job Accommodation Network and get guidelines for that sort of thing. So it's not as difficult as it may sound to work that out. Let's talk about in another different place altogether. What about in your places of access? If you're trying to go fly somewhere, Bailey, and you want to get on a plane with your either service animal or emotional support animal, how does that apply in that environment of flying on a plane, a commercial plane?
Commercial airlines are now regulated under the Air Carrier Access Act, and this protects the rights of people with disabilities on commercial airliners.
Is it restricted like other businesses to only service animals, or can you take emotional support animals?
You can take other emotional support animals, and airline carriers must accept the service animal with documentation, wearing a harness, or with credible verbal assent by the individual who requests to bring a service animal on the plane with them.
Normally done in advance, you give them notice when you make a reservation that you need the
Yes.
accommodation?
Yes.
It's kind of hard to do that if you just show up with the dog at the plane, right? And it's kind of late to straighten that out?
Yes, it's important to note that those who do request any sort of assistance need to do so in advance, as airlines are not required to accommodate passengers with animals that would impede the workings of the plane or issues that may come up during an evacuation and emergency situation.
And one of the only real exception to a service animal being something other than a dog is a miniature horse, which some people have because they live longer than dogs. So is that the kind of thing you're talking about? If you want to take your miniature horse on the plane, you need to let them know and try to work that out?
And most most airlines do try to give individuals with disability bulkhead seats next to the wall so that their animal does have enough room, but animals that are going to be getting into the walk areas or things of that nature can be barred from flying on planes.
What if your seat assignment, you're the veteran that has the service dog, and the seat assignment doesn't work with that? The dog doesn't have a place to lay down, to be out of the way, or there's something else, maybe the exit aisle. What happens then?
I believe that the airline would try to accommodate, but the ACAA does not impose an affirmative duty for carriers to offer assistance to those who do not ask for assistance in advance.
Ms., I want to kind of go to you next to talk something else about service animals. If they show up and they've got an emotional support animal and they want to travel, what's the special documentation that might be required for that?
Well, generally, there's no special documentation. It can't be required of a person traveling with a service animal unless the carrier has reason to doubt that the animal is a service animal after first speaking with the handler, possibly asking what the task the animal is trained to perform. However, a person traveling with an emotional support animal is required to have documentation in the form of a doctor's letter.
And what do you mean by that, documentation in form of a doctor's letter?
Well, a person traveling with an emotional support animal has to have a letter not more than 1 year old on letterhead from a mental health professional stating first that the passenger has a mental health related disability listed in the DSM-IV. It is not just a mental illness diagnosis, but a mental illness. Airlines are not permitted to require documentation to the specific type of mental health disability, for example, panic attacks or anything of that nature. Secondly, that the presence of the animal is necessary to the passenger's health or treatment. The purpose of this provision of the law is to prevent abuse by passengers that don't have a medical need for an emotional support animal, and to ensure that passengers who do have a legitimate need for that service animal are permitted to travel with their service animals on the aircraft.
The issue of somebody faking service animals creates difficulty, even especially on planes, because they can change the fees that they have to pay or don't have to pay. But what I understand that you're saying is if the last time I flew was a year and a half ago and I had that letter, I can't take that same letter back from a year and a half or 2 years ago. I've got to go to the doctor and get a current one.
That's correct. You'd have to have one within a year.
Okay. Let's talk a little bit more along the traveling lines, because the other time that's going to run into a situation when you're traveling is in a hotel. So what happens if you want to take your service dog to a hotel?
Well, hotels have to designate pet-friendly rooms for service animals. They have to allow a guest with a disability to reserve any available room. And they can't charge a cleaning fee for hair shed left by the service animal. They can only charge a cleaning fee if damages resulted from the service animal. So in other words, they can't charge you extra because they know that your dog's going to shed in the room. The only way that they can charge you extra cleaning fee or any fees extra based on your service animal is if that animal actually did damage to the hotel.
Damaged by,
Chewing.
they're not housebroken, they chew furniture, that sort of thing?
Chewing the furniture or destroying some form of the hotel, the same reason why you would get charged an extra fee in a hotel.
So when you say you can rent any room, does that mean they cannot say to you, we have one room that we allow service dogs in and it's full, so we can't help you? Or do they have to give them another room?
No, they'd have to give you another room. You have to have the ability to reserve any available room. So if they did have designated rooms that were all filled up, they would have to accommodate you with your service animal.
I want to go to another area that's not as frequently coming up, but it can be for certain people. And that's what happens with a service dog if you land in the hospital or you're in an ambulance in an emergency. Chet, can you tell us about that?
Certainly. Hospitals will typically allow the service animals or emotional support animals into the public areas and into the patient's room. If the patient is not able to care for the animal, other accommodations have to be made. Occasionally, the hospital itself will make the arrangements as a last-ditch effort, but in any event, the animal must be cared for somewhere, and they can have it boarded if they have to.
So the patient can't demand, well, I don't have any family here and I'm too sick to do it, so the nurses have to take care of my dogs. They can't require that.
That is correct.
There's another area that's kind of a unique area, and that's churches and places of worship. What happens there if you want to take your service dog?
Churches are generally exempt from the ADA. So it would be a case-by-case basis, depending, the institution makes the rules about it, because officially they are exempt.
Just as a place of worship, they're exempt.
Churches are exempt, correct.
Especially sanctuaries and those areas. Maybe not necessarily the gym where everybody goes to play the game, but the sanctuaries.
Yes.
Okay. Are there any more situations that you want to talk about with the places of worship? Is there anything else that's involved with that? Do you need to ask for an accommodation?
You can, again, they're exempt. Can they allow the animal in? Absolutely. If you ask, typically places of worship will accommodate you. They are there to help people.
Okay. That concludes our presentation on access to services for veterans in various areas. I do want to thank the veterans that joined us today to help with that. Chet Southworth, Bailey McShane, and Michael Ludwig for coming and giving us their experience with this and explaining to you what veterans and other people who have disabilities can address when they have rights to housing and parking and to take a service animal with them, which is really a medical device. Thank you for joining us.